SJC-12061, Commonwealth v. Brian M. Grassie.
Mr. Anderson, good afternoon.
May it please the court, I'm Kenneth Anderson for Brian Grassie. I want to thank the court for the second bite at the apple to try to convince you that in this case, that a manslaughter conviction is much more consonant with justice than the second-degree murder conviction, which currently stands.
But this is not a first-degree murder case, so it's not 33E. We have to decide that the trial judge abused his discretion in finding that it was not, that it was consonant with justice, correct?
That's correct, and that's unfortunate. And in preparing for this argument, I went back and watched the argument back in September of 2016. And one of the things that struck me was a comment that you actually made, Chief Justice Gantz, that this puts us in a very screwy world where he would have been better off being convicted of first-degree murder, and then under 33E, if you felt it was appropriate, you could have reduced it to manslaughter, than his current situation now where he's convicted of second-degree murder and 33E is not available to him. I noticed last Friday there was a decision from Justice Lowy, the Tejada decision, where this court actually cut out an exception under the revise and revoke rule out of the sense of fairness and justice in that rule, where generally, obviously the court's aware you couldn't look back at things that have happened after the conviction, but in the Tejada decision, out of fairness and justice, the court did that. And part of what I've argued in my brief here is that I asked this court to consider somehow adopting 33 powers for themselves. I know it's different than adopting or transforming a court rule versus something put in place by the legislature. But in this case, I think even under the very difficult abuse of discretion standard, that all these facts are here. This court's already been through the facts, but when the motion for new trial and the motion to reduce the verdict was filed back in June of 2014, almost 2 years after the conviction, there was a line in the motion that basically said that every factor of mitigation under the law is included in this case. And in this case, the age of the parties involved. Everybody was just over the age of 18. This court in science has taught us that people at that age don't have fully developed brains. And I think that that's a factor that was not considered by Justice Gaziano in denying the motion. Intoxication of all the parties involved. There's no dispute that everybody had been drinking all day that day, and everybody was heavily intoxicated. And last December, in the Salazar decision, this court used intoxication as one of the factors to reduce a first-degree murder conviction to second-degree murder. So I think that's an important factor that, again, I don't think was really appreciated by Justice Gaziano. The suddenness of the fight in this situation. Although this episode had gone on for several hours beforehand with my client being a complete jerk and having confrontations with people, there was never anything physical. And in fact, the only physical confrontation came towards him, where he had a cigarette thrown in his face and he had a hand pushed in his face. And he didn't retaliate in those situations. So even though the verbal abuse had gone on for hours, the charging down the street happened almost immediately. So this is a very sudden situation. I think the location of the fight is very significant for a number of different reasons. First of all, the party was at 29 Priscilla Street. The jury saw this in a view, and I went back and I looked at some of the evidence photographs. And I Google mapped from 29 to 13, where the video camera shows my client walking away as he continues to taunt the group. And it's beyond that point where the altercation occurs. And it's 268 feet. So it's almost the length of the football field, and he's beyond that point when he's chased down the street. So he's long gone at that point. The one-sidedness of the fight. The fact that it was 2-on-1, but it could have easily become 3-on-1, 4-on-1, 5-on-1. The time of...
Wasn't he waiting for them, though?
Well, there was testimony that he said, I'll meet you at the beach in 10 minutes, but he had continued to walk. And and this court did a very good job summarizing that videotape as he walks by and he continues to threaten and taunt, but he continues to move. And he doesn't stop until you can hear the stampede of feet coming by. And it's after that, there's the altercation. And then after the altercation, some type of sensor light goes off, and then you can see the group coming back with the injured parties. But I think that it's important to consider all these factors in terms of the mitigation that I don't think Justice Graziano appreciated. The location and the direction of the stab wounds. Again, all the stab wounds were primarily to the legs and the buttocks, and they're all in an upward direction. They're all self-defense. The fact that everybody in this group were strangers. My client knew Dylan Burns because Dylan Burns had a summer house in the area, and my client lived in the area. But everybody else was from a different part of Massachusetts. They were all from the Oliver Ames High School, and they weren't people that were going to encounter each other on a regular basis. The fact that my client had no record, and again, the fact that the jury acquitted him of assault with intent to murder on Brian Mahoney. I think all those factors are significant. And in Justice Graziano's decision, when this case was sent back to him to sit as a single justice, he essentially ruled that the defendant had sought out the fatal altercation and was the initial aggressor, which I would dispute him being the initial aggressor because he's 100 yards down the street, and that this wasn't a sudden altercation where he would have been taken surprised by the action. And those are the two things that were allowed him by Justice Graziano in his written findings coming back to the court. Again, he never noted the age, the lack of a fully developed brain, the intoxication, the location, the darkness in this area. I went back and reread the testimony of Brian Mahoney, and he described it as something where you knew somebody was there, but you couldn't see them. I mean, this was a fight in the pitch black that occurred. And again, they were all strangers to each other. And I think in this fact pattern, I think abuse of evidence is evident here.
I mean, we obviously struggled with this case, and we understood that there were two visions of what occurred. One is that he had essentially, knowing he had a knife, invited people to have a fight with him so that he could use the knife against him. And the second vision of the case was that he was acting like a drunken jerk at the party, but didn't really expect that they were going to come chasing him, and when they did, he was backed up against a fence and used essentially excessive force and self-defense by using his knife. Those were the two visions of the case, which was why we wanted to hear from the trial judge when he ruled on the Rule 25 as to which vision of the case he thought was most consonant with justice. He's made clear that the first vision is one that he believes is supported by the evidence. So if that's the vision of the case the trial judge determined, why is he wrong to uphold the second-degree verdict?
Because again, he didn't address any of these factors. He didn't address the fact that this is a kid who just got out of high school, 18 years.
I think everybody knew that. I mean, I don't think there's any, I think we all understand that everybody understood the age, everybody understood he was drunk. It was really these two competing visions of what occurred, which was the reason to ask the trial judge now as single justice to make those determinations. So
Well, I think the problem is, and I think it's human nature, that once you say denied, I'm not going to disturb the verdict, and then someone sends it back to you saying, we invite you to consider these other cases because of what the court called striking factual similarities, you're going to dig your heels in. And that's what happened here, is I think he dug his heels in. He went and took out all the worst facts, but he didn't look at the mitigating factors. And I think that that was an abuse of discretion. And again, I would just ask out of a sense of justice and fairness, if there's a way that this court can review this under 33A, I think that'd be a much more appropriate disposition in this case, because I do think the mitigation.
You want us to do it instead of Justice Graziano, right?
I'm sorry, I didn't hear you.
You want us to do it instead of Justice Graziano?
Yes.
Uh-huh.
I mean, he had the opportunity, I guess, to review under that standard, and he chose not to, and we're
But this
suggesting.
time he chose the right standard, right?
He did choose the right standard,
There's no question about that.
correct. But we're suggesting that he got it wrong and he abused his discretion in so doing.
Because he saw the facts differently.
Yes, obviously. But I would ask you to,
This is a brawl between young adults engaged in chest-puffing braggadocio. Why isn't that taking into account the youth?
but again, I think it's the science, it's the unfully developed brain. And I think had he reduced it to manslaughter, he could have meted out the same sentence. He could have imposed a 15 to 15 in a day sentence, but then you have some finality to this. He could have taken into consideration my client's lack of record and some of the positive things in his life, but with a second-degree murder conviction, there's really no choice. And at sentencing, there was really nothing put forward about my client because the judge, it's just 15 years, see the parole board. And the problem is if you don't get paroled to 15, then it's 18, then it's 21. And in this case, he could have had the same outcome, the same sentence imposed essentially, but it would have been a final sentence. And he could have imposed a sentence of 12 to 15 or 10 to 12 or 15 to 15 in a day. And at least my client would know that that's the end of it. And I would ask you to do that. Thank you.
All right, thank you. Ms. Yashoulis, good afternoon.
Good afternoon, Your Honors. Laurie Schultz for the Commonwealth. I'd like to begin, obviously, with the standard overview as abuse of discretion, and that 33E is statutorily barred here. So we could all agree on that situation here. Under Rivas, under LL, what this court now looks at is whether Justice Gaziano created an error of law in weighing the factors relevant to his decision, such that that decision was outside the range of reasonable alternatives. And I think this court agrees that in the Grassie decision, that second-degree murder was found here, and what the evidence supported that. So now Justice Gaziano has looked at this case 3 times. He was the only justice to hear and see the evidence at trial. He was there. He denied the motion for required finding. He denied post-trial motion for 25B2 on the reduction of the verdict. He was in the unique position of sitting on this court when the first case came out, when the first case was argued, and so this court transferred it to him, looking for some sort of written findings, because as Chief Justice Gant stated, this was a close case in the court's view. Not in the Commonwealth's view, but in the court's view. So Justice Gaziano went and looked at the evidence again, and it is true when he wrote his first decision, his first memoranda, he did cite to the Lattimore standard as well as the consonance with justice weight of evidence standard. It's the Commonwealth's position that when he reviewed the case, he did so properly, but this court was concerned that it might be construed improper, so we sent it back to Justice Gaziano again. And I suggest, rather than dig his heels in, Justice Gaziano wanted to make sure that he got it right. He reviewed everything. He reviewed the mitigating circumstances, and he points them out. The defendant's age, that he was intoxicated. He even states in his decision that the defendant was being chased down the street by a group of what amounts to essentially 5 people, that he was outnumbered. And even considering all those mitigating circumstances, he still found that he was firmly convinced that the jury got it right, that the jury's verdicts should stand. And I think in this court's historic high regard for our criminal justice system and respect for a jury's decision, he did get it right. So under Commonwealth v. Pena, this court looked at a case under 33E review in a situation where there was alcohol involved, and it was, in that case, the defendant asked this court to, and let me back up just a little bit. That case, there was no error at trial, just like here. That case, there was no error in the instructions, just like here. And still, in the Pena case, the defendant was asking this court to review under 33E whether or not the mitigating circumstances that case were enough to modify a jury's verdict. And this court said, our regard for the criminal justice system requires us to use restraint when we modify a verdict. That's exactly what Justice Gaziano said in his second decision and in his first memo to this court. Regard for the criminal justice system requires us to use restraint. And so when you look at everything together, Justices, you will look at, this is a defendant who's taunting his victims all night long, at least an hour. He's taunting his victims. He's targeting the Mahoney brothers. He challenges them to go meet him down the street in 10 minutes by the beach beyond the street light. He waits in the darkness. He turns in a ready stance. And as he's taunting his victims all night long, he's got a concealed knife in his pocket. Nobody there knows about it. There was evidence of one person in the basement who was aware of it, but none of the Mahoney brothers were not aware of this concealed knife. So regardless of whether or not he was outnumbered, he was intoxicated, his young age, he stood in ready and wait, taunting his victims, and as Justice Gaziano suggested, that was the initial aggression, taunting his victims, waiting for them. There was no suddenness, there was no spontaneity. He waited for them in a ready position, waited for his victims to ascend upon him in the darkness, and pulled out his knife and stabbed them. And the location of the stab wounds are important too, because Brenda Mahoney received 5 stab wounds, Brian Mahoney received 3 stab wounds in a very short period of time, and they were all targeted in both victims' midsections. That's significant because it suggests that he was targeting the locations on where he was going to stab his victims. And that is significant to this defendant's intent, is significant to what he was planning all night long, is significant to the fact that this was not sudden, this was not spontaneous, and it's contrary to all of the other cases, as Justice Gaziano points out, where the suddenness was the factor that swayed this court and swayed the appeals court. Here, there is no suddenness. The defendant knew all along what was going to happen. He invited it, he waited for it, he planned for it. To the extent to suggest that Justice Gaziano did not consider all those mitigating factors, now having looked at this case 3 times, is incredible to suggest. And I might add, Your Honors, that I would ask the court, as an aside, to strike some of the footnote 1 in the defendant's second supplemental brief, where he suggests that this court should ask the sentencing judge, should the court remand back, to consider that has no place here to consider his conduct in jail, and I would ask the court to strike footnote 1 of his supplemental memoranda. I ask that this court uphold Justice Gaziano's decision now for a 3rd time and find that he has not abused his discretion here.
Okay, thank you.
Thank you, Your Honors.